Is it true this application was coming up for further cross-examination? However, my Lord, further cross-examination of Joseph Kyomuhendo. My Lord, this was an application for witness protection where prosecution sought to protect the 6 witnesses. And my Lord, 6 witnesses. And my Lord, the defense made an application to have Mr. Kyomuhendo Joseph, the deponent for the applicant stroke prosecution, to be cross-examined. My Lord, this cross-examination started from 23rd of April 2026, 23rd of April 2026. It crossed to 6th of May 2026. And now today, the 28th of May, 2026. My Lord, as prosecution stroke applicants, we have realized that the continuation of these proceedings under this miscellaneous application number 101 of 2026, the witness protection, are delaying the commencement of the hearing of the substantive case, the actual hearing of the substantive case. And as such, the prosecution stroke the applicant is applying to have this application withdrawn as we consider other appropriate protection measures for the 6 witnesses which we deem will be effective, appropriate, suitable, and above all practical, without affecting the expeditious trial of the main case. Because any further delay, my Lord, will be contrary to Article 126 to be. Will be delaying the main trial. is therefore our prayer, my Lord, that although there is no specific law or section to have this application withdrawn, we believe that this court has inherent powers under Section 37 of the Judicature Act, Cap 16, to grant any remedies to any party before it, and the application for withdrawal of this application not being exception. It is our belief, my Lord, that the withdrawal of this application would serve the wider interest of expeditious justice. It is therefore a prayer that, my Lord, you grant this application and have this application withdrawn to enable prosecution to make full disclosure of the said 6 witnesses and we have the substantive case, my Lord, fixed for hearing. Without much delay, we so pray, my Lord.
Yes, we have no objection to the withdrawal of the application, but we are urging that the court allows the withdrawal with prejudice. Just as the court said, we have no objection to the withdrawal, but it will be with prejudice, that you cannot bring the same application again, especially so because the prosecution has waited for the court to utilize 2 days of cross-examination of the witness, yet nothing new has happened. They could have evaluated the options open long before they brought the application. We therefore believe that the application has been made at this stage because the prosecution has realized through the cross-examination that their application was ill-advised and has no grounds to stand on. We are therefore asking the Lord that the court takes the unusual step, utilizing its inherent powers to allow the withdrawal on a prejudice basis, but to also take the unusual step to award the defense costs of the 2 days this application was prosecuted, which cost should include my airfare from Kenya and back for 2 days. Because it is unnecessary that for any of us to bring an application where you have other alternatives. We also seek the courts to require the prosecution to obey its earlier order on full disclosure and to give a timeline. So that we may return to court for scheduling and for the court to be satisfied that the full disclosure has been made and therefore the case is now ready to proceed.
My Lord,
Yeah.
My Lord, invite court to find that there was no prejudice in the withdrawal of this application.
But what happened, you are drawing will not again be valid again. I think that is it.
Yes. With prejudice means he cannot come back for the same purpose.
My Lord, I was going to it. It is also, my Lord, it would be very unfair for court to say never bring any application of that sort again. We did this application because it was taking a lot of time. Precisely. So whether it comes up or not is an issue of a reassessment. And then, my Lord, prosecution cannot be condemned to costs this matter because it had no control over the period when cross-examination took place. And in any case, my Lord, the record has it, my Lord, I made it categorically clear on the 23rd day of April 2026, before Kyomuhendo Joseph could be cross-examined, that the matter, that application be expeditiously had on that same date. And I'd even prayed to ensure that each advocate is given specific time within which to cross-examine. And my Lord, it was the discretion of this court that counsel for the respondents or the accused persons take their time in cross-examination. That explains why you have taken all these days, my Lord. So we pray that this court finds that application, my Lord, redundant, given the circumstances. It is our prayer, again, that, my Lord, this application, as court, since you have not objected to it, it is withdrawn unconditionally. There shouldn't be any conditions attached to it. Because our focus as prosecution is to have an expeditious trial of the main case, which we think should be the focus of witness to solve.
And it is not in this case that the defense is objecting to this application, save for two prayers that the defense team has made. That is to allow withdrawal of prejudice and the request for justice. It is my considered view that the issue of prejudice is premature at this stage. Court cannot give orders in advance, or it will be speculation to know whether they will file another application of the same nature or not. But that one can be considered if a thought is there. On the issue of costs, it is my considered view that this court allowed this application and cross-examination for the interest of justice. Now, since the same has been, since the prosecution has now made application public withdrawn, the issue of costs, in my view, cannot silence the interest or the entire interest of justice. So I'm inclined to grant costs. So in the view of the above, this application is allowed to be withdrawn with no order, costs, or prejudice. However, basing on the time this application has taken and the time the main case has taken, I will make the following orders. One, the prosecution is ordered to make a full disclosure by tomorrow, not later than 5 p.m. Should have made full disclosure by tomorrow, not later than 5 p.m. Two, this honorable court will now proceed to make some other directions in the main case, which was coming formation today. So,